Hi, Juliana. Hi, Juliana. Hi.
Good afternoon. Good evening, ma. So we are starting now. I hope everybody can hear me. Good evening, everybody. Good evening. Good evening. Hello.
Good evening.
Okay, my name is Christiana Longe, and I'll be anchoring the program for today. I'm a lawyer and I'm also an ex-mentee. So first of all, we are going to start with introduction, what the program is all about. JIIPCC Mentorship Program. Mentorship and Internship Program is a quarterly intellectual property mentorship program for law students, young lawyers, and intellectual property enthusiasts across Africa. Mentees are afforded the opportunity to access valuable intellectual property advice, training, network, mentorship, internship discussion, forums, industry updates, and resource materials from experienced IP mentors. This program seeks to encourage continuous intellectual property training, development, and evolution in Nigeria, Africa, and around the world. You can watch our videos by searching for JIIPCC on YouTube and Facebook. The objectives of the program are to provide easy access to intellectual property guidance, training, and resource materials for students, young lawyers, and IP enthusiasts in Africa, to facilitate dialogue and network among experienced, less experienced intellectual property practitioners and stakeholders, to transform mentees into intellectual property mentors and leaders for the next generation of mentees, to facilitate further intellectual property mentorship, internship scholarships, and IP-related job placement for the mentees. So this evening, we are going to start with the mentees presentation first. So I'll be calling on group 1 to present. Group 1. Is anybody from group 1 here? Okay, group 2. Anybody can present. Group 1, group 2, group 3, group 4. Anybody can present that is here, that is present here. Hello, can anybody hear me, please? Hello?
We can hear you. I guess they are not here. So maybe we'll just move straight to the mentors.
Okay. Okay, so.
Yes, we can hear you.
Okay. So we'll go to the mentors presentation, and the first mentor that I'll be presenting this evening is Mr. Ayokunle Adetula. I can see you are here, sir. You can unmute yourself.
Hi, good evening.
Good evening, sir.
Good evening, sir.
Thank you very much. I guess I would ask that we have some modifications to things. I guess the essence of the presentation, because we've had the opportunity to go through some of the presentations by the mentees, the draft that they submitted, our presentation would make much sense and impact if they have the opportunity to run through their presentation so that whatever it is we're talking about, it should be able to pull out probably some of the things that they have omitted in their own presentation and then act to things. At the time you were doing that introduction, I think a couple of them were not in, but then some of them just joined now. So I don't know if you would then decide to go back and call on them to do their presentations, and then we'll come in and fill in some of the gaps that we think is important.
Okay, sir, that would be very fine, sir.
Okay, so I think Blessed is here for group 3.
Okay.
Blessed is around for group 3. Please, if you're here and you're supposed to present, just unmute yourself and kindly present. Thank you.
And you have 5 minutes for your presentation, please.
Blessed, can you hear me? Please, if you can, kindly unmute and make your presentation.
And if anybody that is in representing other groups are here, they can as well go ahead with their presentation as well if Blessed is not ready. Okay, Blessed, say just a minute.
Blessed just sent me a chat saying just a minute. So I don't know if probably he's in a place where he can't talk. I don't know.
Okay, Juliana, do you mind if I maybe go first to give them time to settle and
Yes,
then?
Yes,
I think I'll go ahead. Regina, will you kindly share my slides, please? So before Regina starts sharing, I recall we've had a session on counterfeiting before. So, and there has been further developments in this area because, as you know, the lockdown is still on. So people are not fully back to normal lives. So we continue to do everything from home, streaming and shopping from the comfort of our living rooms. So, and that has really changed the way we do business and live our lives. And then in the same vein, counterfeiters are also taking this opportunity, to continue to carry on with their illicit trade. So the introduction, the restriction around the world kind of forced consumers to shop from home, and consumers got better by this because shopping from home, everybody's sharing experiences, and then we'll continue to stream everything from entertainment to restaurant orders. And so oftentimes you find out that people are perfecting and are more advanced with this shopping, that we have gotten used to it. It's so comfortable that I doubt if people will ever go back to the usual brick and mortar stores, and brand owners in the same vein are also closing the usual brick and mortar stores and moving online. So the demographic that is heavily affected in this kind of practice, like shopping online, ages 25 to 34. And these are people that grew up with digitalization in this digital world. They're actually the digital citizens. So they're so used to it that everything is done from home. And the industries that are hugely affected are usually the fashion and the luxury goods. As you know, it's as if brand is a fashion statement. Everybody wants to carry Louis Vuitton or Chanel. So these are the industry that are heavily affected during this lockdown, that the counterfeiters are putting everything online and people are confused and buying fake, thinking them to be the original. And brands are, like I say, are closing up their normal brick and mortar stores. And the counterfeiters, they continue to carry out this alongside these developments because, I mean, shopping from home, it's innovation. People are, it's digital technologies are good and it triggers economic growth, but it's just unfortunate that at the same time, counterfeiters will always find a way to turn good into bad. So they see a loophole, an avenue to continue to enrich themselves. Next slide, please. TikTok, I mean, is so popular, and then it's the emerging threat from TikTok, China's TikTok, is it's like connected to the rest of the world, to the countries. I know recently television one of the TV celebrities was online taking a phone through TikTok, and the scammer that was trying to scam her was really like talking. So they were having a conversation and then she recorded it. And then in the middle of the conversation, she said, oh, that FBI is roped in into this call. And the scammer quickly hung up. I mean, the TV personality is able to do that because she has all the resources to do that. But you and I, if somebody had called and engaged us, we give all the information and all of that kind of causes trouble. So it's online, shopping online is good, but there's been a mix. All of these bad people have gotten online and pushing their businesses, their illicit trade alongside the genuine products. Then the emerging trends, live streaming. Everything is being streamed. Even the retailers are using influencers, celebrities, and they're also something like people are engaged in stealing other people's identity. So you find that if there's an influencer and then somebody will want to pose as that person. So it's really very difficult because it's online. People sometimes are in a hurry. You don't look and double check to see. The scammers have also resorted to sending emails and sending email using your colleague's email account that is fake, only because we don't know. When you say, see, for instance, Uche Nwokocha, oh, okay, that's a bit, you need to click on that name to see that that is not the genuine email. So they're really using this to really scam their way around people. And these are really, it increased with the COVID-19 and the lockdown. Then, of course, the social media, like Wechat. Wechat is so popular in China and it's linked to financial services. So if they manage to hack into your account, there's grave danger. And I was alarmed when recently I learned that in China, they actually use it to pay salaries. So you can imagine, they have come up with that technology thinking that this is simplified and is good for people. But then the danger is that counterfeiters have also come here, and then with one click, it can be so damaging. Then the celebrity blogs and Instagram, and I've mentioned identity theft. So it's all like scammers, and some brands are using influencers. The influencers are really taking over the brands, because everything is about online, who is popular, who can influence your decision. But when these bad people have a way and get in online, everything is messed up. So I guess it would be that people should really watch, And then, of course, with the scammers, even law firms are not immune. We learned recently in a report that a law firm, I think a paralegal, didn't check. It wasn't in Nigeria, didn't check properly and allowed a payment. But then the scammers had hacked into the original email. They actually interject themselves and redirect the money to them. So if the money is supposed to go to your client in millions of dollars, they just change a few things and they're patient. They can do it for what, from the research you've done, they say they can wait for 2 months for a target. So they're watching you, seeing your behavior, how you check your email, things that come. So that's when they start taking stock of the emails, the kind of people you relate to, and see if you're like a heavy spender and they see you a target, this is the kind of person we can really infringe upon their rights, or maybe try to fake, or maybe try to scam you of your resources. E-commerce is a new trend that is really like hot now, also as a result of COVID lockdown, because it's an opportunity for you to resell maybe fairly used items. And during the COVID, and we are not going out, was going for any dinner party or luncheon and stuff like that. So all our clothes are in the wardrobe molded. So people could just clean it up and sell it here. And it's usually for 1 hour, and it's you get the price in real time. So you can imagine a scammer or a counterfeiter really coming within that space of 1 hour. They can quickly do things and get off, and you can't get them because it's only for 1 hour. It's not for a long time. And the way you know is that the product will not appear more than once, because you and I, if you want to sell a bag, it will just be one bag. But these people, if they want to sell, there are about 10 of them to tell you there's more where it came from, that this is really counterfeiting. And it's also for the younger people who want to identify with brands. So at least they can buy a fairly used one and feel okay about it. But the sad thing is that counterfeiters have come into this platform and abusing and messing things up and selling their fake products also to the unsuspecting buyers. Data collection and monetization. It's no news that data is king. So now people do not know that what you put out there is really, it goes a long way. So for instance, sometimes you'll be asked by either Spotify or any other network, free trial, then you lash in on it, put on your information, goes a long way, and they can use your data to study not them because you trust them, but then the data, if it's out there, it gets into wrong hands. And it's not only those platforms, even in our offices, you give your data to HR, and then you have health insurance, and the hospital, they have all your information. Or maybe you're applying for vehicle license or international passport. All of these, your data is everywhere. So, and people take it and then monetize it. So you need to be careful what you put out there, which is the reason why Netflix will always suggest your viewing pattern, or Amazon, or the airlines. Sometimes you find out that your phone, things will be dropping, people are marketing you because your data is out there. They know that you're a traveler, you're always traveling, or you always, so they know your viewing pattern, your travel pattern, your spending pattern is through the data that has been compromised, that they are able to get all of this information. Next slide, please. Lack of enforcement, especially during the lockdown, because especially for instance, when Nigeria closed down, NAFDAC, SON, all of them, nobody was going to work. So if there's somebody counterfeiting online, it's so difficult to track them. Apart from the usual takedown procedure, it's very difficult to catch them. But if it's like the offices are open, the enforcement is readily done in a physical situation where they probably work with custom and pound the goods and seize it. But if it's online, it's gone, and then oftentimes what you bargain for is not what you receive, because they sell you the counterfeit for the price of the original because you're not watching. And even if you're watching, it's so difficult to detect the counterfeit. So it's really a menace. And okay, even with the test, we know that the COVID test, I mean, it's common. In the dark web, you can print doctor things up and then print COVID-19 result. Even if somebody has COVID and tested negative, positive, they can go and get negative results. So it's everywhere, it's so common. Okay, now with the test, they've gone a bit slow on tests. They are now need to latch on to the COVID vaccination certificate. So now there's fake everywhere, and it's all over. It's causing confusion all over the world because people are carrying fake vaccine certificates that are not the original. Next slide, please. Action points. So financial services should have multi-level security. Some of them are doing it already. Sometimes they tell you to put in the last 4 digits of your card or the middle digits. Sometimes they send you a code to your phone. I know oftentimes I get codes on my phone from Apple that I didn't ask for. So to tell you, thank God for security that Apple has adopted. So you can imagine somebody is trying to scam, but Apple and so many others, some banks will send it to you. That's the way you will know that somebody's trying to scam. And then unfortunately, the person cannot, because they didn't know that financial institutions have put all of this multi-level security, sending it to the actual owner with the information you have on file with them for you to check. So sometimes they will ask you, if you didn't request for this, either report, let them know, so it's kind of a very serious situation. There should also be collaboration between e-commerce channels and brand owners. And there should be also collaboration between the enforcement officers, brand owners, and e-commerce channels. They should be working together. And it's a holistic approach. You can't just say it's SON and it's not NAFDAC, or it's GSK, it's not Pfizer. They must come together to work for a way to really reduce the impact. Not that they can stop it completely, but at least to reduce the impact. And also insurance. I think businesses should really take out insurance against ransomware. We've had instances where they will hack into somebody's system, take some secret information, and then ask for money. And then if you start paying, you're in trouble because you pay, they still go, they keep sending it around. So it's really a bad situation that the government should really see counterfeiting as a global threat. The same way they view terrorism is the way governments should come together and fight this. I'm not leaving it to the individuals that are victims to fight. And security also should not be an afterthought. You should see it as an investment. When you're starting business or when you're having your budget for the year, you must really create a certain amount for security and insurance and all of that to be well prepared, and then put some gadgets in your office to make sure. There's a company that is called Scam Advisor, which is good, based in Netherlands. So they have a software that if you put in your system, you can detect the email that is scam. So things like that. I think people are coming up with innovative ways of really keeping counterfeiting down. Finally, and not finally, we should really try and protect our phones and all our devices. There are people that have their password so common, 1, 2, 3, 4, 5, 6, 7, 8. You should really make it difficult and then keep your phones to your chest, don't expose it. Then I'll end in closing. I'll just run down a few best practices. Awareness, you need to raise awareness, let people know. Some people do not know about an IP address and the dangers and things that are happening. So they do not know. I think people should be educated whether on TV or the regulators, they must, the same way we send information on WhatsApp and text, that's the way they should really send intelligence update to people to be aware so that they don't fall victims. Next. The Shop Safe Act has just been passed in the US, and then it mandates a number of best practices to be implemented even by the e-commerce platforms. For instance, informing or taking down somebody, a third-party seller, maybe on the Amazon platform, if they suspect that the person is selling counterfeit, take it down and shut them down. So these are expected. Otherwise, you will be viewed as you're contributing to the counterfeiting activity, and you will be viewed as not a good corporate citizen. Also, the Inform Act is also pending, but that is an act, if passed in the US, will mandate the e-commerce platforms to inform people if they get an inkling that some counterfeiter is operating in their platform, you must raise alarm so that people know and not deal with this kind of person and blacklist them. Also, measures to expand the custom border and give them authority so they can stop and check. And then also, if there's any shipment that contains counterfeiting, you know, there's always mislabeling on concealment, so that if they find a thing like that, they should be empowered to publicize it, name and shame, so that people will start embarking on this kind of illicit trade. With that, I'll stop here, and if there's any questions, I'd like to take your questions. Thank you.
Okay, thank you very much, Ma. Ma, I don't know if you can help us with your slide. Our mentees need it to read further, Ma.
Okay, fine. Of course, we share
Okay,
it.
thank you, Ma. Okay, we can now go to the presentations now. So is Blessed available? Or anybody else in group 1, group 2, group 3, group 4 can present? Okay, please go ahead, Blessed.
Good evening, everyone.
Good evening.
Good evening, Ma. Please, permission to share my slide on the screen, Ma. Hello, Ma.
Yes, you can,
Ms. Christina.
you can share your slide.
Okay, thank you.
You're welcome.
Okay, I think that you can start your presentation while you're trying to share your screen, please.
Okay. Basically, I'll be speaking on trademark opposition. So before I directly dive into trademark opposition, I first of all want to talk briefly on what trademark is. So basically, now a trademark is something that an individual, organization, or an entity identifies with. That basically these are what they are known for. If you take for Google, for example, now Google basically they identify with these 4 colors: red, green, yellow, and blue. That's how do you know if you've seen your most Google apps like Chrome and other Google apps like Files, you see these are the basic 4 colors now. And also there are also examples of other organizations that, or rather, colors and trademark is not necessarily restricted to colors. It can also be extended to statements like, take for example now, MTN, everywhere you go. Basically, these are the things that we know them for because why? They identify with it now. So now the question is, what is a trademark opposition? Now, a trademark opposition basically is when an individual comes to oppose, or when an individual comes to oppose the registration of a certain trademark based on certain reasons. Please, if I can continue, if I need to continue, I will need to share my slide.
Sorry, is it just me or has he stopped his presentation?
No, he said for him to continue, he has to share his slide.
Okay, then we can move to the next mentor that is present while he gets everything ready.
Blessed, are you ready to share your screen now, or we'll go ahead? Hello, Blessed.
Please, ma, just go ahead. Just go ahead. Like, I'm finding it difficult to share my screen. Please just go ahead.
Okay, is any other group ready, please?
Yeah. Yes, I
Okay.
am ready.
Okay, what group are you presenting for? Group 2.
Yes.
Please go ahead. Since your network is bad there.
I apologize for that. There's something wrong. Okay, hi.
All right, go ahead, please.
Thank you. My name is Omoshifumi Emmanuel from Omoshifumi. I want to share my screen with you.
Can you just be presenting while you share your screen?
Sure. Okay, so I'll be talking about trademark registrations, and as Blessed said when he started, we're all familiar with trademarks. We all know how trademarks are distinctive features, distinctive markers of products or products, brands. They make them distinguishable from one another, and in that sense, that trademark becomes an essential part of the product itself. The trademark or the distinctive mark becomes what you use to distinguish the trademark and the product or the brand from others that are similar to it. 1 second. So when it comes to registration, I have come to recognize that there are two phases to it. There is the basic one that is general, where it pertains to trademark owners or people that have businesses and brands. But there's also the part of trademark registration that applies specifically to agents and lawyers, as the Act calls them. It calls them accredited agents. So, right, here it is. Okay, to start with, can you see my screen?
No, please just go ahead.
Okay, to start with, the first process to trademark registration. All right, the first process to trademark registration is the search to recognize whether
Omotoye, are you there? Hello?
Can you hear me?
Omotoye. Yes, your time is you're almost running out of your time, please.
Let me go straight. The requirements for application in Nigeria are very simple. The first one is application details. It has information like the full name of the applicants, the nationality, and the physical address of the applicants. Then the second one is the trademark information. This is where the representative, as I said earlier, there is the part that pertains specifically to the trademark owner, the owner of the trademark, and there's also the part that pertains to the agent. So the agent here might be called a representative. Now the representative is going to submit certain forms. It's going to submit details of the applicants and the goods. Now, this trademark information that are going to be submitted, they are mostly filled online, and they contain soft copies that, according to the registration and specifications, they must be 1,200 DPI.
Okay. Omotoye, are you still there? Hello? It seems it's having network issues. Please, is anybody else present?
So it is these forms, these soft copies have to be. Can you hear me?
Yes, go ahead, please.
Thank you. Now, the fourth item on the list is the power of attorney. This is that part that authorizes an agent. It authorizes an individual or a representative to carry out the registration process on behalf of the trademark owner. All right, so the procedures for trademark registration, the first step is the search and the application. This is where you confirm whether there has been an existing trademark or a similar mark or similar symbols with the one you're about to register. So if this search turns up negative, and that is when it turns out that there is no existing marker or similar symbol to what you want to use, you can continue with the registration process. And the next step is going to be the acceptance. This is where the registry accepts and registers the trademark and issues an acceptance letter to the applicant. The acceptance letter is always the initial evidence that the trademark has been duly registered. Now, the third one is the publication and certification. This is a stage where notices have to be sent all over to inform the world or inform citizens and other trademark owners that this particular trademark has been registered. That says it sends out notices. Now, the notices to be sent the notices to be sent have to be sent on national newspapers and trademark journals. They have to be sent all over so that everyone that comes across this trademark can recognize that it has been taken. So the final part is the renewal of trademark. Now, trademark typically lasts for 7 years. And after this 7-year period, it can be renewed from time to time, and the renewal, subsequent registration should last about 14 years. Thank you.
Okay, thank you very much, Omotoye. Who else is ready to present, please?
Good evening, everyone.
Good evening. Okay, Blessed.
Yes, good evening, everyone.
You just have to continue from where you stopped.
Okay, no problem. So as I was saying earlier, I basically explained what trademark is, what a trademark proposition is. That's a proceeding that is intended either by an individual or basically an individual opposing the registration of a certain kind of trademark. So the question is, what is an opposition? It is a quasi-judicial process, and it can only be handled in a trademark registry center. And it's suffice to say that there's only one trademark registry center in Nigeria, and it can only be located in Abuja. So basically now, the question now is, who files an opposition? This is made provided for in section 20 of the Trademarks Act, and I quote, any person may, within 2 months from the date of publication, give notice to the registrar of opposition to the registration. Now, one mistake that many and most IP attorneys make is that they restrict the registration, they restrict the opposition of a certain trademark registration to basically the IP, IP proprietor that registered that certain trademark that is similar to the one that's about to be registered. But that's not so. According to the provisions that was just read now, that's section 20 of the Trademark Act, it said any person. So in other words, it's like an open check. It's an open check to the entire world for someone to come and oppose the registration of that certain kind of trademark. So, and also another question, and also basically now the article says that you must also state the grounds of your position in the notice. Now, this again is also another mistake that most IP attorneys make, and they believe that the trademark can only be they believe that the trademark can only be opposed when it is similar to yours. So basically, you can put a trademark if you do not have a registered trademark yourself. So it is not registered to any individual stereotype to one particular reason. The Act forbids the registration of a mark that can cause confusion in the market or that is contrary to law. So in this sense, an opponent can oppose the registration of a mark if he believes that the use of the mark is likely to cause confusion in the market. Take, for example, now, initially when I started my presentation earlier, I made reference to Google being known for basically 4 colors, which are red, blue, yellow, and green. Now, someone who just comes into the market now and wants to come and register his trademark, and basically he wants to be known for these 3 colors, so these 4 colors now. There's a tendency it can cause a confusion in the market. Now, on that ground alone, somebody has the right to come and oppose him. So basically now there are grounds for filing a notice of trademark opposition, and I will list them right now. Number 1, the trademark must be confused. Yes, the trademark must be confusing because it is similar or identical to a previously registered trademark. I still draw back your attention to the ones the Google mark I made reference to. So the trademark contains deceptive or scandalous matters or design. Now, basically, scandalous in the sense that it can bring damage to the specific brand that is similar to. That's what I mean by that is, if you are registering a certain kind of color and it's similar to another color, there's a tendency that it can damage that specific brand you are trying to counterfeit, you are trying to copy. Thirdly, the trademark contains names of chemical substances, use of the coat of arms of Nigeria, use of any emblem or title such as the president or governor without appropriate authorization. Like basically now, when we're being taught IP in the class back then, we're made to know that there are some restrictive words that cannot be registered at all, which are basically, and to an extent, these words are basically related to governmental powers. And fourthly, the trademark contains geographical names. Fifth, the trademark also contains some restrictive words or symbols. I also make reference again to those to the words such as president or governor. Sixth, the trademark is devoid of distinctive character. When you see the trademark is devoid of distinctive character, it means that there is nothing so peculiar about it. Like you will know that this brand is known for this. If anyone thinks of MTN aside from their logo, which is aside from the letters in their logo, which is blue, the next thing someone thinks about is the yellow color MTN. And also, the applicant of the trademark has no intention to use it now. You just basically that's all it is. And lastly, the applicant is not the true owner entitled to register the trademark. So when an opposition is filed, the registry sends a copy of the notice of opposition to the person who applied for the mark, to the person who applied for it. So the applicant has a period of 1 month to answer to the opposition by filing what we call a counter statement. Now, 2 months can only be given for the opposition, and the 1 month is for the counter. So these duration which are provided for are not extendable. Not even COVID-19 lockdown has any chance of extending it for you. So if the applicant fails to file a counter statement, its trademark application will be abandoned and will not be registered. And if the applicant ends up filing a counter statement, then the opponent will have to file evidence by way of statutory declaration. Now, this is very much similar to an affidavit, which is usually filed in a normal standard court proceeding. So this statutory declaration is where the opponent supplies evidence of his own ownership or use of a mark, the grounds of which is opposing the new trademark application by another person who wants to register it. So a copy of the opponent's statutory declaration will also be sent to the applicant, who will also file his own statutory declaration on detailing grounds why he wants to register it and why the grounds of the opposition should not be adhered to, and also evidence why he is entitled to the mark will not be presented. The opponent has the right to reply, after which written address will be filed, then a hearing and a ruling delivered by the tribunal. And please, lastly, the time frame for the filing of the statutory declaration and the written address can all be fixed or extended by the registry. And normally, the trademark regulation says 1 month, but the 1 month can also be extended. So that's basically all I have to say as pertaining to trademark registration. Good evening, everyone. Thank you very much.
Okay, thank you very much, Blessed. So moving next to group 4 to make their presentation.
Okay. Good evening, everyone.
Good evening.
I'm making the presentation for where I am. I'm presently unable to share my screen, so I will just go ahead with the presentation like that. Please just kindly listen. Thank you very much. So we're supposed to talk on counterfeiting. I really want to say a very big thank you to our mentor, Mrs. Uche, for a lecture she delivered. It was really very enlightening, and I want to say that I will just what we have from our group is a little bit different from what she spoke about, but it's like going to definitely add up to everything she said, and I'm happy she even presented before us. So this would our presentation will just clarify a few things statutorily and all of that. So basically, what is counterfeiting? We all know that counterfeiting is a threat worldwide to businesses and all of that, because brands take time to build their brands and their reputation, and then someone within like weeks or months can just do stuff to destroy their reputation. So anti-counterfeiting is anything that is done to prevent an IP theft, or generally preventing an IP work from being fraudulently copied or being fraudulently used or being used in a way that the owner did not authorize. And like our mentor already said when she gave her lecture, it's highly necessary to take steps to prevent counterfeiting of your product or of your brand. So basically, that's just a way of trying to introduce it. So what are the adverse effects of counterfeiting? First of all, if your goods or your brand is being counterfeited by someone else, it will definitely affect your brand value and result in loss of revenue, because someone is out there selling probably a fake of your original product. So there will be a fall in sales. You won't make as much profit as you want to make. Another adverse effect of counterfeiting is for companies like pharmaceutical companies that make drugs that humans take. If drugs are counterfeited, we know that it can result in very serious health challenges and even in some instances, even death. So that's a very big adverse effect of counterfeit. Another effect is, I think I've already mentioned this, it puts in jeopardy the reputation that brands spend years to build. So every brand should try to make effort, put measures in place to prevent their product from being counterfeited. Then another adverse effect of counterfeiting is that if your product is being counterfeited and you discover it, the process of trying to seek redress takes time and it will be expensive. So it's better, like they say, prevention is better than cure. So it's always better to take measures to prevent your brands from being counterfeited. So and then it draws revenue from the business. I think I've already mentioned that. So I think the next thing we have on our slide, is the legislations that provide for counterfeiting or that fight against counterfeiting in Nigeria. So some of the legislation that provide against counterfeiting is Copyright Act of 2004, the Counterfeit and Fake Drugs and Unwholesome Processed Foods Act of 2004, the Customs and Excise Management Act, the Cyber Crimes Prohibition Act of 2015, Merchandise Act of 2004, Note Tab Act of 2007, Nigerian Police Act, Patent and Industrial Designs Act, and then the Trademark Act. Also, the EFCC Act also provides against counterfeiting. So I'm sure there are so many other acts out there that provide against counterfeiting. So some of the regulatory bodies in Nigeria that help to fight counterfeiting, I think top on the list is the Consumer Protection Council. Okay, so basically the Consumer Protection Council, it provides redress for unfair trade practices, and it was also established to help consumers get redress for unfair or deceptive practices against consumers. So then another regulatory body that helped to fight against counterfeiting is the EFCC. We discovered that Section 46 of the EFCC Act provides that economic crimes also includes theft of intellectual property and piracy. So here, the EFCC Act also classifies IP theft and piracy as an economic crime. So they also fight counterfeiting in Nigeria. Another body that helps to fight counterfeiting in Nigeria is the Standard Organization of Nigeria. So the Standard Organization of Nigeria is responsible for registering and regulatory standard marks and specifications for both local and imported products in Nigeria. So they have the Standard Organization of Nigeria has power to enter premises and seize or destroy products that are found to be dangerous or substandard, or products that are in violation of the SON Act. Then another regulatory body that also helps to fight counterfeiting in Nigeria is NAFDAC. We're all aware of that. Has to do with food, drugs, and anything related to food and drugs that are counterfeited. NAFDAC would definitely come for you. Then the Nigerian Customs, of course, set up by the government to fight counterfeiting by checking for contraband goods, and basically they ensure that all import and export duties, first of all, are collected and paid, because we know in Nigeria a lot of people would not want to pay the correct fees, they would want to cut corners. The Nigerian Customs, of course, is here to ensure that all duties are collected and paid to the federal government. And then they also have the basic task of stopping contraband and fake products or counterfeited products from entering into the country. So whether they are really doing that is, well, so basically those are the some of the regulatory bodies that help to fight counterfeiting in Nigeria. So what are the measures? I think our mentors really dealt with this. She really spoke on this, but we have a few here that we would like to add. What are the measures that brands can put in place to fight counterfeiting of their brands or their products? First of all, registration. Of course, you have to register your brand. For your brand to be recognized, for you to be able to protect it, you have to register, let people know you for a particular brand, and then you can start from there. Registration, you start from registration, and then if you're a holder of a right of, the owner of a brand, as the owner of a brand, you should carry out regular market surveys to ensure that there's no unauthorized use of your trademark and all of that. So when you carry out periodic market survey, you can know if your product is being counterfeited or not. And then other measures that the owner of a brand can take to ensure that his product is not counterfeited is educating customers. Like, you can do adverts, jingles to tell people out there that, okay, there are some fake products out there, it doesn't represent us, and then put out the real product so that when people want to buy, they can see the difference. Try to bring out the difference between the original and the fake. So you can educate customers and have a strong social media presence, and then where you establish your business as being authentic. So basically, those are some of the measures that a brand owner can put in place to fight against counterfeiting. So in conclusion, I would like to say that counterfeiting has become a global threat that must be dealt with both offline and online. So it's everybody's responsibility. Once you are an owner of a brand or the product, then you should definitely take measures to ensure that your product isn't counterfeited out there, because it will affect your business adversely. Thank you very much.
All right, is group one ready to present?
Yes.
Okay, please go ahead. You have just 5 minutes.
Okay. Good evening, everyone. I'm presenting on behalf of Group 1, and our topic is on trademark classification. Sorry, I won't be able to share my screen. A trademark is a symbol, word, or words legally registered or established by use as representing a company or product. A trademark may be placed on a package, a label, a voucher, or on the product itself. Nigeria presently follows the NINE's International Classification of the NINE's Agreement 1957. A separate application is required to be for each classification of goods for which a trademark is to be registered. So the following are the classes of trademark in Nigeria. 1, products, goods / classes. The first class is chemical products. Chemicals used in industry, science, and photography, as well as in agriculture. Class 2, we have paint products, paints, varnishes, preservatives against rust and against deterioration of woods. Then class 3, we have cosmetics and cleaning products, for example, bleaching preparations and other substances for laundry use, lotions, hairs, essential oil, perfumery, etc. Class 4, lubricants and fuel products. We have industrial oils and greases. And class 5 are pharmaceutical products, pharmaceutical and veterinary preparations, sanitary preparations for medical purposes, and then preparations for destroying venom. Class 6 are metal products, e.g. common metals and their alloys, metal building materials, transportable buildings of metal, materials of metal for railway tracks, etc. Class 7, we have machinery products, e.g. examples are machines and machine tools, motors and engines, machine coupling and transmission components, etc. Class 8, we have hand tool products, for example, cutlery, sign arms, razors, etc. Class 9, computer and software products and electrical and scientific products. Class 10, we have medical instrument products, e.g. surgical, medical, dental, and veterinary apparatus and instruments, artificial limbs, eyes and teeth, orthopedic articles, suture materials, etc. Class 11, environmental control instrument products, apparatus, e.g. apparatus for lighting, heating, steam generating, cooking, refrigerating, etc. Class 12, we have vehicles and products for locomotion by land, air, or water. Class 13, firearm products, e.g. ammunitions and projectiles. Class 14, we have jewelry products, precious metals, alloys, etc. Class 15, musical instrument products. Class 16, paper and printed material products. Class 17, we have rubber products, for example, rubber, gums, goods made from gums, plastics in extruded form for use in manufactures. We have class 18, leather products, not including clothing. For example, we have leather or imitations of leather, and trunks, traveling bags, etc. Class 19, non-metallic building materials, e.g. non-metallic rigid pipes for building, pitch and bitumen, monuments, etc. Class 20, we have furniture products, for example, mirrors, picture frames, shell, amber, mother of pearl, etc. Class 21, we have houseware and glass products. Class 22, we have ropes and fiber products. Class 23, yarns and trades, for textile use. Class 24, we have fabrics and textile products. Class 25, clothing and apparel products, e.g. footwears, headgear, etc. Class 26, we have lace, ribbons, embroidery, and fancy goods, e.g. lace, ribbons, and braids. Class 27, we have floor covering products, e.g. rugs and carpets. Class 28, we have toys and sporting goods products, Class 29, we have meat and processed food products, e.g. poultry and game, meat extracts, etc. Class 30, we have staple food products, e.g. coffee, tea, sugar, rice, tapioca, etc. I'm sorry about that, please. Class 31, natural agricultural products, e.g. horticulture and forestry. Class 32, light beverage products, e.g. beers, minerals, non-alcoholic drinks, food drinks, etc. Class 33, wines and spirits. Class 34, smokers products. Then we have the service classes, and we will look at class 35, advertising and business retail services. Class 36, insurance and financial services. Class 37, construction and repair services, e.g. building construction, repair, installation services. Class 38, we have communication services, and these are services allowing people to communicate with one another by essential means. Then the last one is, the last class is transportation and storage services, and these include transport, packaging, and storage of goods and travel arrangements. So these are the various classes we looked at in our group, and I hope we've learned one or two from this presentation. Thank you so much.
All right, thank you very much, Ineka. We'll be moving now to the presentation by the mentors. So now Mr. Folari is to make his presentation now.
Hello.
Good evening, sir.
Hi, good evening. How are
I
you
can
doing?
hear you. You're doing very
Okay,
fine.
great. Good evening, everybody. Just to be sure, my audio is good and my video. Christina, yeah, sound check and video
I can
check.
hear you very well. Yes.
Oh, great. Okay, good evening, everyone. Fantastic stuff. I joined earlier. I caught Ms. Nwakocha's presentation, and I must say, always a pleasure to listen to her. And it's always an opportunity to learn. So very quickly, I don't know, can I share my screen?
Yes.
Okay, so I'll just do that right away. I've been asked to speak on trademark opposition, and I find it quite interesting that we've had another presentation on trademark opposition. So I don't know. I'll try and cover areas that don't necessarily overlap. But let's see how that goes. Okay, so can we all see the?
Yes, we can.
Yeah. Okay, great.
Yes, sir, we can.
And it's full screen?
Yes.
Okay.
Yes, sir.
Okay, so again, thank you very much for having me. My name is Folari Aliko. I am a partner in Truman Rockwood Solicitors, and I'll be speaking on Introduction to Trademark Opposition Proceedings. So very quickly, trademark opposition proceedings, as has been said, are quasi-judicial proceedings that exist to challenge offending trademark applications, after the applications have been approved by an examiner, but before the issuance of the certificate. So someone talked about the registration process. I think one of the preceding groups talked about registration process. You filed your application, it has gone through the preliminary research, it has been examined by a trademark examiner and approved. Or if it was refused, an appeal has been lodged and the appeal was successful. So it's been approved by an examiner, which means it meets the requirements for registration contained in Section 9 of the Trademarks Act. And then at this point, the mark is advertised in a trademark journal. Now, opposition proceedings are not unique to Nigeria, but not all jurisdictions have opposition proceedings. The idea is to invite comments from the public, as to whether they have reservations or objections to the grant of a trademark license. We shouldn't forget that a trademark right is a monopoly right. So it's practically a monopoly over words or over symbols. Imagine that somebody were able to exercise a monopoly over the word Yoruba, as happened somewhere in the UK, where the UK recently, we recently found out that the UK IPO had granted somebody a trademark over the word Yoruba. So the idea for opposition proceedings exists as an administrative way to resolve these disputes. Disputes as to similarity, as to likelihood of confusion, as to passing off, as to offending public morality, public order, and so on and so forth. So yes, some jurisdictions have adopted trademark opposition procedure as the best way to deal with these name similarity issues. So essentially, again, as we said, it's quasi-judicial in nature. It's a little technical, and it's also time sensitive. And trademark, the opposition process arises after the advertisement of accepted applications published in the Trademarks Journal. A lot of people, I find that a lot of people say, oh, publication, your mark is published. No, your mark is not published. The mark is advertised. The journal is published. So it's advertised in a journal that is published by the Trademark Registry. It's not advertised in a newspaper or in two newspapers like Incorporated Trustees are, but it's advertised in a trademark journal, which is exclusively published by the Trademarks Registry. At the moment, the Trademarks Registry publishes physical hard copy journals, but you find, excuse me, jurisdictions like Kenya, where the Trademarks Registry publishes soft copy PDF, PDF versions of the trademark journal, which makes for cheap, easy, and speedy publication of trademark applications. So again, now the opposition procedure becomes mature. It matures at the point of publication of the journal. So once the mark is advertised and is published in the trademark journal, then it becomes mature. The process commences with the filing of a notice of opposition in Form 6. You have trademark Form 6 at the top of the notice of opposition. And an interesting case, J Laboratories against James Aidu. It's an unreported Federal High Court case where the court explains the rationale for the advertisement or the publication of the trademark journal, advertisement of marks in the Trademarks Journal. And the court in that case said essentially that where the mark is not opposed, or if there's an opposition and the opposition, either notice of opposition has expired or the opposition has been declined or decided in favor of the applicant, then the registrar has no other option but to register the mark and issue a certificate of registration. J Laboratories against James Aidu. What are the applicable laws? Again, you guys have done a lot of work in that aspect. You mentioned some of the laws. You have the Constitution of the Federal Republic of Nigeria, the Trademarks Act, the Evidence Act, the Oaths Act, Trademark Regulations, the Federal High Court Civil Procedure Rules 2019. I should also mention the Federal High Court Act, as well. And I'm not sure if I should include this, but perhaps maybe the African Charter on Human and People's Rights. That's the reason why I would mention that, because I've taken a look at the constitutional provisions that deal with ownership of the right to own property. And I don't think our constitution grants the right to own property, that's movable property. What the constitution seems to grant is the constitution grants the right to own immovable property. And then it also grants the right to compensation in the event that one's movable property is acquired. And so in that real sense, it appears that the 1999 Constitution, as amended, does not grant a positive right to own property. But if we look at the provisions of the African Charter on Human and People's Rights, which the courts have held in a plethora of cases, has primary standing or premium standing in the hierarchy of Nigerian laws. We find the existence of a right to own property, both movable and immovable property. And of course, trademarks are property. We look at the Evidence Act and the Oath Act because opposition proceedings involves the taking of evidence. So who are the parties to opposition proceedings? You have the opponent or the opposer, who is the person who is objecting to the registration of a trademark on any of the grounds contained in the act, or on grounds of even passing off. You also have the applicant, so that's the person who applied for the registration of the mark. The opponent / opposer is the plaintiff, or in this case, the applicant is the respondent or the defendant. And then in all cases on appeal, the registrar is a party. During the proceedings, the registrar is the arbiter, supposed to sit as an arbiter. And in practice, what you find is that at the moment, the trademark registrar has delegated hearing of opposition proceedings to senior assistant registrars. So they sit in panels to determine opposition proceedings. So again, the proceedings are commenced at the Trademarks Tribunal, which the Act equates. The Act sometimes uses the registrar and tribunal interchangeably. So the registrar is the tribunal. The Act also, the Trademarks Act, gives the minister the power to delegate duties and powers that can be performed by one person to any other officer of the trademark registry. And I believe that was the basis upon which the hearings are. So that's by virtue of Section 1, Sub 3 of the Trademarks Act. So that power has been delegated to senior assistant registrars to sit, essentially. So that's what happens in practice. You won't, if you were to walk into the trademark registry, on a hearing date, you might not find the registrar of trademarks sitting at the trademark tribunal. And that is just practical. The registrar has so many other functions, statutory duties and roles created by the Act. The registrar is supposed to sign certificates. At what point in time, will the registrar be able to manage all these several functions? So the power of delegation is granted. On appeals, the Federal High Court has exclusive jurisdiction. So the appellate jurisdiction of the Federal High Court can be found in Section 251, paragraph F of the Constitution of the Federal Republic of Nigeria, 1999. So essentially, it gives the Federal High Court exclusive jurisdiction to determine matters arising from decisions of the trademark registrar. So the Federal High Court actually sits in both original and appellate jurisdiction in matters that deal or that touch on trademarks, federal enactments relating to trademarks, copyright, patents, and other forms of intellectual property. I should mention that its original jurisdiction has to do with federal enactments. That's very important. I think is what emphasizing. Emphasis is mine. So that's the judicial forum. So what this essentially means is that you shouldn't, a person who intends to oppose to the registration of a trademark should not go to the Federal High Court, file processes at the Federal High Court. The proper venue for opposition purposes is the Trademarks Registry or the Trademarks Tribunal. Now, on appeal, since we said the Registrar of Trademarks is a nominal party or is a party on appeal, the provisions of Order 53, Rule 3 of the Federal High Court Civil Procedure Rules 2019 provide that the registrar must be served in all proceedings, must be served. So for that purpose, you can't serve a party that you don't serve court processes on a person who is not a party to the lawsuit. And so the registrar has to be joined as either a nominal or a necessary party, to any opposition proceedings or to appeals arising from decisions in opposition proceedings. And when sitting on appeal, the Federal High Court, the judge, in chambers or in court, has all the powers of the registrar and can grant any power or any order that the registrar has the power to grant. So orders of rectification, of correction of the register, and so on and so forth, including consequential orders as well, can be made by the court. As a matter of fact, the court can actually even call for an oral hearing, because opposition proceedings, evidence in opposition proceedings is taken by way of statutory declaration. A statutory declaration is not an affidavit, and is slightly different from an affidavit. But when evidence has been given by statutory declaration at the trademark opposition before the tribunal, and that evidence is to be taken on appeal, the statutory declaration will be treated as an affidavit by the Federal High Court. But the Federal High Court sitting on an appeal from the trademark edition of trademark registrar can call for the hearing of oral evidence, viva voce, as it's said in Latin. Burden of proof, on whom I thought to just have a quick conversation on some preliminary or peripheral evidential issues. I find that in practice, a lot of people don't really understand on whom the burden of proof lies in opposition proceedings. So generally in most civil cases, the burden of proof lies on the party who would fail. The maxim is he who asserts must prove. I think if you look at section 140 of the Evidence Act, and of course, section 135, 136, 137 of the EA, 140 talks about facts within someone's personal knowledge. So if you have facts in your personal that you know of, you have a duty to prove. And we know that usually the second or the third, the first, second, or third paragraphs in an affidavit often say that the facts deposed to herein are facts within my personal knowledge. So the burden of proof lies on the party who would fail if no evidence is given. In opposition proceedings, generally that starts with the opponent or the opposer. But in certain circumstances, the law allows for what you call certain presumptions to be made. So where, for example, an allegation of trademark infringement is made and a trademark certificate is tendered, it shifts the burden of proof to the applicant in that case to establish that infringement has not occurred. So we just talked about how the evidential burden may shift in certain cases. So if you look at section 40,
Hello?
Well, I guess he might be having a technical issue. So maybe we can move to the next speaker while we wait for him.
Hello? Network issue. Is Mr. Ayokule Adetula.
Okay, good evening.
Mr. Ayokule.
Good evening. Can you hear me?
Sir. Yes, very well, sir.
Great. So, can you see my screen?
Yes. Yes,
Great.
sir.
All right. So, what I'm going to do is I've listened to some of the discussions, and I'm just going to run through very briefly what I have, and then, like I mentioned initially, point out some of the issues that I think it's important for the mentees to take note of. Trademark classification. The discussion so far had mentioned what we use is a nice classification of goods, and classes 1 to 34 is for goods, class 35 to 45 is for services. Editions of this classification of goods are published every 5 years, and versions of the editions are published every year since 2013. And usually these versions enter into force on January 1 of every year. Now, basically what that means is that there are some major changes to some of those specification of goods. If we try to look at it, we'll find out that some of the classes, some of the goods may try to look similar or somehow related. So basically what those amendments and review does is where there are new things, they are incorporated into the system. Well, an inquiry we made at the registry actually indicated that we are using the 10th edition, but at least we are aware that there is the 11th edition. But from a practical standpoint, if you file using the 11th edition, there is a possibility that it would be allowed to go through the system. Now, one thing that I think it's important is individuals that made presentation have talked about conducting an availability search to determine if the mark you're thinking about is actually available or can be registered. And to that extent, it's important to then look at some of the types of marks that one can register. From your screen, you probably see Coca-Cola trademark, you see Google, you see Logitech, you see Angry Birds, you see the New York Times, you see Puma. There are some of these marks. Google is just a word mark. When you look at the New York Times, Coca-Cola, you can see that the letter is done in a very funky manner, using stylized fonts, and basically those are referred, yes, word marks, but then they are stylized. Then you look at what Puma is. Puma has more like a composite mark that has both the name and a device, to it, and there is the mark that has beer. That's also a trademark, Now, what I think everybody, or specifically the mentees, should understand is sometimes you carry out availability searches that show that your mark, probably there is a mark that is probably not too similar, but yes, can be termed to be similar, and probably they are word marks. What you can do as an applicant or as probably an agent working for an applicant is to add a device like you have in Puma, or to do something like the New York Times to sort of distinguish what you have from what is available. And then once applications are filed, presently at the Trademark Registry, you can file online through their website. You can lodge at the registry, which they call IPAS. One way or the other, they also indicate that this is an online system, but then properly referred to as IPAS. Once applications are lodged, acknowledgement forms are issued, and then the mark then goes to examination. Examination is basically to look at what the records of the registry in that particular class. Usually that examination at that point is restricted to the particular class to see if there is any confusingly similar or identical mark on the register. If there is none, then the mark will be accepted. But then one important thing that I think we should also note at this point is that if availability searches are done, which are optional, and then an individual finds out that, oh, there is a particular good that seems similar, but the goods that the trademark is being used for is not the same as its own. Like we have in class 25, we have clothing, footgear, headgear. You know, you are using a particular trademark just for sandals. You do not have a plan to use it for any other thing. It's advisable that you don't use the general classification. You just restrict it to that specific good you are using. And I think in some jurisdictions like the United States, that is what is always been advised. As a rule of thumb, the broader the specification, the likely it is that a mark will be opposed. Interestingly, I think I should also mention, during the one of the presentations, we're talking about acceptance. You know, before now, one of the issues that we've always seen in practice is that people ask for the date, especially for online applications. What we have at the registry at some point in time was that the date of acceptance is usually the date in which the acceptance letter is stamped. But then what we have presently, because there are two online platforms that the registry is running concurrently, the newest approach to things is that the acceptance date is actually on the acceptance letter, and you would even have the name of the official that worked on that application. So that then cuts out questions around when was this application accepted. That being said, we talk about opposition proceedings. One thing that is important in opposition proceedings, Mr. Folarin was already having that discussion. Sorry, I'm having some issue with my, okay, good. So now for Oppositions, publication, once an application is accepted, it moves to publication. And he made a very clear thought. Journals are published and marks are advertised in the journals. That is very key. Sometimes we look at it and say it's semantics. But then for opposition proceedings, you see, there are a couple of things. The reading of the act says any party can, oppose a mark that is published in the journal, which should be within the space of 2 months. But I think one other thing that is important to reiterate is that filing an opposition is not an open check. Now, you may say it's an open check also, but then that check is open only to the extent that you have a ground against or on which you are basing your opposition. Because then the act provides that your notice of opposition must contain the grounds. The grounds are the basis where you can then proceed to make issues or to push issues on your application. It's that is very, very important. And some of the things that could make or mar an opposition is, I just identified a couple of them. That is need to identify the proper parties. In some cases, Mr. A would file a trademark, will have assigned to Mr. B, and sometimes the registry has not updated its systems. He files, and then because it's Mr. A that files the trademark comes published in the name of Mr. A. Mr. B has taken ownership after filing assignment. These are issues that could make or mar an opposition proceeding. Also, it's necessary that where issues as to the root of title is in issue, proper identification, providing proper background to the issues and tying it to the law in your notice of opposition or counter statement is key. Now, there is need to also provide appropriate evidence in your statutory declaration to support your averment, either in the notice of opposition for the opponent or the applicant in their counter statement. And some of those things that you probably will want to use, maybe newspaper clippings, maybe you have been using the mark and then you want to say, oh, my mark has gotten some level of notoriety in the market. You want to probably provide evidence of advert materials, probably billboards or whatever it is. Then in some situations, you want to, for services where you are particularly not selling goods, you want to probably say, oh, I can confirm that my mark is already known in the industry. In my website or my social media pages, we have maybe some millions of views this year or within so months, or we have so number of followers in a specific period. That also helps to convince the tribunal when they listen to your views. Then one can engage experts to conduct surveys. Now, something that is important, I think we also should mention. The COVID-19 presented us with a very rare situation, not only in Nigeria, but across the world. And the thought that I've had on the discussion so far is that, oh, these positions, the timeline of 2 months to file the notice of opposition or 1 month from the receipt of the notice of opposition. These timelines are not extendable. These timelines are not extendable. But the reality of 2020 tells us that those timelines, not just in foreign jurisdiction, but also in our jurisdictions, those timelines, because when the registry was closed, you could not have filed anything. The registry was closed, you could not have filed anything. So across United States and some other countries, and even here, Nigeria, the registry had to make arrangements to ensure that parties set out timelines for parties to file immediately after. For cases of statutory declaration, the registry had a notice to say they are not going to extend timelines more than once. But then because of the realities of the COVID, the registry had to extend even more than once. You would agree with me that that power to extend is a discretionary power. They reserve the right to either extend or not extend. And that is what they've always said. But because of the circumstances of the situation, they extended timelines. So, and that is also very important as we have these discussions to take in practical insights, to be able to think and fashion out innovative ways to deal with issues. Now, for your written addresses, once evidence is filed by the different parties, it is important that written addresses will be filed. Written addresses will tie your facts, your grounds with the relevant cases. It could be law, it could be secondary sources, it could be decision of courts, it could be revered authors in the field. There is need to then tie your arguments into a ball to be able to convince the tribunal that the mark should either be refused registration in the case of an opponent, or in the case of an applicant, for the mark to proceed to registration. For registration and renewal, once publication is done within 2 months and there is no opposition, you can then proceed to pay. Or when the opposition process is concluded, you can then proceed to pay for the registration. I think with the person that made presentation was clear. I think Omotoye mentioned that the first renewal is 7 years and subsequent renewals is 14 years. The question that we have also had in practice is parties asking, when does this 7 or 14 years start to count? That question is quite important. And from practice, 7 years starts to count at the point where you file your application. So if your application was filed in 2021, your 7 years will start from 2021 to probably 2020, sometimes in 2028, depending on the time. So if you say January 1, then you say 7 years is 2022, 2023, 2024, 2025, 2026, 2027, and then January 1, 2028, you should be thinking of filing your renewal. And then the same thing, from the date of the first renewal, you calculate your 14 years after that. So that is, I think, a brief running through registration procedure in Nigeria. So I'll take questions or comments from listeners, mentees, mentors. Thank you very much.
Thank you very much, sir.
Very much, sir. Thank you very much, sir, for the presentation. So I have some questions here, and this is on trademark.
Okay, so I guess I will just put the questions together, Christina,
okay,
so that both Mr. Ayokunle and Mrs. Uche can answer them. Mr. Folari had to leave, sorry.
So can I read the questions out now?
Yes, please, thank you.
Okay. What is the difference between a trademark, a service mark, and a trade name? Is a trade name eligible for registration? That's the first question. The second question is, can a domain name become a registered trademark? For example, a URL or a website that is used to sell. And the third question is, can an individual register the assignment of a trademark? If yes, what are the different types of assignments? Then the fourth question is, what are the effects of counterfeiting in Nigeria? And the fifth question is, what are the strategies that can be used to overcome the impact of counterfeiting? That's all the question I have with me. And some of the questions are in the chats.
Okay, so with the permission of Miss Okocha, I will just touch up, then she can provide a bigger response if there is anywhere I've not touched.
No, you're too kind. Ayokule, I think I will defer to you. So answer all the trademark related, then I will answer the counterfeiting. Thank you.
All right. So trademark, service mark. There are differences. Trademark deals specifically with goods. Trademark deals specifically with goods. Service marks, by their name, deals with services. Now, you would understand that as lawyers, we don't offer goods. We offer services. So we would not proceed to register as our brand, like Alukano Yebode, as a trademark, rather as a service mark. So the major distinction is that trademark specifically relates to goods, service marks relates to services. Now, if you take your time to look at the nice classification of goods, you would likely see the breakdown. You likely see the breakdown of the details, the specifications, the things that those classes relate to. When they say advertising, consultancy is basically for services. Medical services, class 5 relates to drugs. Then I think class 40 something, 42 or 43 relates to medical services. So if you have an hospital that is not providing drugs, but treating patients, they would rather register as a service. They would rather register whatever their name they have as a service mark. And then the person that produces the drugs they use will register as a trademark. Oh yes, a trademark name may be registered. A trade name may be registered. And I think that reminds me about the person that talks about MTN. Everywhere you go is actually a tagline. It's called a tagline. You can incorporate that to what you do. If you've had a trade name that people have already known you for, I think one of these major communication companies, Etisalat, I don't think Etisalat didn't particularly incorporate as Etisalat initially. I think it's EMT something. That is what they registered as. But what we then know in the market is Etisalat. That was their trade name. And then they registered this to become something that people can know them with, can identify them with as an insignia to their origin. So, yes, can a domain name be registered as a trademark? Oh, yes. We talked about Google. Google, when you go, you say www.google.com. The global system allows you, there is the components of your domain name. There is a distinctive name in your domain name. So you say www.google.com, www.samsung.com. That distinctive part of that domain name is Google or Samsung. So it is registrable to pick that distinctive part and register it. Now, as to say whether I can now say, oh, I want to register my trademark as www.google.com. I suspect that in some instances, or you say google.com, in some instances, people would say it would fly, but it's more of an overkill. What you actually need is to take that distinctive part of the domain name, which is Google or Samsung, or as we have at -oyebode.com. We are not saying what to register. We're not saying, oh, we are registered Aluko-Oyebode. We are known as Aluko-Oyebode, but what we have online is Aluko-Oyebode.com. But what people see us in the market as is Aluko-Oyebode. So we take that part, the distinctive part, Aluko-Oyebode, and then what we are known for in the market, and then we register it. So I think that sort of clarification to that. Then can an individual register the assignment of a trademark? Oh yes, you are even expected to register the assignment of a trademark. Once a mark is assigned from Mr. A to B, an assignment operates to take away every right that Mr. A has and vest it in Mr. B. So it's a total, it's an absolute transfer of property rights in a trademark. So to be able to exercise ownership, you are expected to register that assignment. And the evidence of registration will be that a certificate of assignment is issued to you. Now you can file that at the registry. So you are expected, and sometimes a mark could have been registered before it was assigned. So what it then means is that the registration certificate will carry the name of the initial applicant. So like I mentioned, Mr. A registered. If it was assigned to Mr. B after it was registered, then when you are doing the renewal, you are expected to file an application for renewal, and then attach a copy of your assignment certificate so that when the certificate of renewal is issued, the name changes from A to Mr. B. Now, the dangers of not doing that is that if your assignment is not registered, you cannot claim a right in law on that trademark. So you need to register an assignment for the assignee who takes ownership of that mark to be able, you know, to take active steps of ownership on that particular trademark. I think I'll stop there and allow Mr. Wechat to go.
And of course, you've done brilliant work explaining, but let me just add a few examples, because sometimes we run the risk of being too technical and some students might not understand. So I'll just offer a few examples to what you rightly described. For instance, with the trade name, oftentimes CAC is the agency responsible for registering trade names or companies, except if it's, for example, Coca-Cola company. The trademark is Coke, Coca-Cola, they have the trademark Coca-Cola. Their trade name also is Coca-Cola company, the Coca-Cola company. So in that instance, it's okay. You could, it happened that they're using their trade name as one of the trademarks. And as you know, that's not the only trademark they have. They have Fanta, they have Sprite, but it happened that one of the trademarks is also the trade name. Then with the domain's name registration, fine, very brilliant. Except that in some cases, people, if they can't steal your trademark, they steal your domain name. So oftentimes we advise clients, as you're registering your trademark, also register domain, because if they check with the NIRA, Nigerian Internet Registration Agency Association, if they check and you're not registered there, they could go and register in bad faith, hoping that you'll come and buy it from. NIRA has been doing fantastic work, because if you complain, they actually call the parties, and if they find out that your trade name, for instance, is not Coca-Cola, the Coca-Cola company, but you went and registered Coca-Cola-.com, then they know that, you know, clearly you're stealing it. Before I go to anti-counterfeiting, let me quickly clarify a few things the mentees mentioned. You know, I think it was Blessed that said that anyone, he read a provision of the opposition from the Trademark Act of 1965, that anybody can oppose. No, anybody can comment on maybe the registration. You have a say if somebody is registering and you find out that a good citizen, that, oh, they put the Nigerian Code of Arms, or that is immoral, or they're using things that are repugnant to public policy and stuff like that. But for opposition, remember in law, we are taught the doctrine of nemo dat. So if, on what ground will you as a third party, you're not an owner of a mark, you're not challenging this person because you feel they're stealing your mark, why would you want to oppose? The only people, when they said anyone can oppose, part of the people that can oppose is either you're the applicant, you're the agent to the applicant, or you have consent, or maybe you're a licensee, that the owner gave you a license to use the trademark in Nigeria. Then you can oppose if somebody is trying to say that mark, because you know that the owner is probably based abroad and you're the licensee, so you're seeing. But as for saying that anybody, if you're not, that's why in the registry, for you to file anything, you need to show from one, which is the authorization of agents. So you need to, you can't just come and then oppose, yeah? Okay, and then somebody else mentioned that, oh yes, one of the mentees was trying to confuse registration of trademark with anti-counterfeiting. There are two different things entirely. Registration of trademark or your brands had to do with your trademark. Anti-counterfeiting is seeking to fight somebody who is trying to counterfeit on your product. Your product is different. It just happened that your trademark is attached to the product. But what somebody is counterfeiting is your product. They can actually take a copy of your product, put their name in it. So they are not, what's the word? They are not contravening the provisions of the Trademark Act. They have not stolen your trademark, but they've stolen your product, or your product, their process, the way you make your product. And then that's why the agencies that are responsible for stuff like that, NAFDAC, because they had to do with product or Standard Organization of Nigeria for non-food items. So there are two different things. So the kind of registration you expected to carry out in terms of counterfeiting would be registration with the customs. That's what they call the customs recorder. But in Nigeria, we don't have it. Very few countries have it, except for civilized societies, the established big countries like America, they have. So in Nigeria, our shortcut to customs registration is signing memorandum of understanding with customs, MOU. So most brand owners, in order to ensure that their source, the production, the supply chain is monitored adequately, they sign MOU with customs. So in appreciation to what custom is looking at for your product, because you have given them key indicators what to look. There's some countries, some companies will tell customs that their goods come only from South Africa or India. So if you see it from China or Latin America, it's fake. So you need to let custom know all of this when you sign the MOU. Then in return, you can help the custom by training their officers. We are not saying bribe them, but you can give them also a computer or some devices, to help them do their work, especially now everything is happening online. So it's just in the agreement, you say what you do for custom and what custom will do for you without money exchanging hands. Okay, so I think back to the question on the anti-counterfeiting, if I recall, it says the effect of counterfeiting, can you clarify, is that the question, the effect of counterfeiting in Nigeria?
What are the effects of counterfeiting in Nigeria, and what are the strategies that can be used to overcome the impact of counterfeiting?
Oh, okay. Okay, the effect, of course, it affects consumers. You buy fake, you do not get what you bargained for. You paid good money for Rolex watch, but they send you the fake. Then for the country, they deny revenue. The revenue they don't pay, because these people, they don't pay tax, and they don't even have staff that work. It's like a slave labor. They don't care. They probably get people and put them in a garage and they keep churning things out. So they don't follow the hygiene, so everything they do is, they don't have overhead. So they're greedy. They just do this thing and take all the money. So instead of paying tax for government to provide good roads and education and health for you and I, they just take the money and siphon it and then maybe use it for terrorism. You never know. Then that's the effect on the country. So everybody suffers, all the stakeholders. So that's to the individual, and then their health and safety. If they don't use the hygiene guidelines, especially now there's COVID, they probably don't care. They do everything and spread COVID, and then they sell bad. You might be buying a mask thinking that this is the right mask and it's the contaminated one or the one, because they didn't follow the hygiene. So, so these are some of the things. And of course, the impact on labor. If you have a genuine company and they counterfeit their goods and they cannot meet their budget and the bottom line and no profit, they close down. So we lose our uncles, our brother, they lose their jobs, not lose their uncles, sorry. The uncles, the brothers, the children, the friends will lose jobs. So there's also job loss. So these are the effects. So what can you do to, give me the second question again, I'm sorry.
What are the strategies that can be used to overcome the impact of counterfeiting?
Okay, so the strategies will be, working mainly pushing, having pressure groups like you have ACC, have people that really speak against it, work with the government, because one of the mentees had mentioned the laws, and all the laws that the mentee had mentioned, while they're good, but some of them are not really, apart from the EFCC one, some of them are not really like, they don't make it a crime the way the Mercantile Act makes it a crime, except that it's outdated. So the penalty that they put, something like maybe, did they say $100 for every day you continue in the infringement on this? So these are laws that were drafted many years ago when 100 Naira was a lot of money. But now the penalty is not stiff enough because you need to hit their pockets. So what can be done would be like awareness. And I think we'll start by individual. If they don't have customers, they won't be in business. So it's you and I that patronize them. You go and buy fake Rolex because you want to wear Rolex, and you buy fake Louis Vuitton because you want to. So if we can catch people young, the way the cigarette companies were getting students young, just get them into the habit of smoking and they smoke for life. That's the same way we should really go and then speak to students in schools, appeal to their conscience, especially the Gen Zs, tell them that carrying a brand is no big deal. Just carry the genuine thing, the genuine leather, and it will last longer for you. So we need to advise people. I know in my office, we always talk and joke. Sometimes I joke with my team, what you're streaming, is it legal? That, did you pay? Did you get consent? So we joke about it. So, but we all know. So you need to really make people aware. And I remember that a client of mine said that she said to her father in South Africa that what you're buying is like you're encouraging a thief. And that was when it sank with the father, because they were thinking, so you need to really appeal to people. Tell the young people that the more they do that, the funding is used for child labor and for terrorism. So let them know that you're not just, because some people will tell you, these brands are rich, so why? They're not just rich, it's an investment, they're using money to do that, but for you, for morality's sake, help, you need to really do some of these. So these are the things you can do, contribute your own, in a little way. You can speak against it when you're amongst your friends, tell them, don't buy those CDs on the street that are fake, go to a recognized store and buy the real thing, and help people that pay tax to continue to pay tax, so you and I can have clean water and schools and good roads. Any more questions? I think that's.
Do we have any more questions? Okay. Christina, would you like to end the session, or should I?
You can go ahead.
Before then, I would like to really thank all the mentees. Like I keep saying, anytime we come here, we learn. There's always, these people are really, if we were like that when we were in school, these people are so determined. They do research, they bring topics that some points that I haven't heard before, and I will develop and research it more. So I really encourage them to continue the good work and pass it on. If we do that, very soon, IP will be something that be known in every corner in Nigeria. I would not say that it's not offered in the university. So your mentees are really brilliant people, and I say kudos to every one of them. Well done.
Thank you
very
so
much,
Ma. Thank you, Ma. Thank you, Christina. Thank you for mentoring. Some of us don't know, Christina just had like a baby and she's here. She's a superwoman. Thank you so much for coming to Anchor today. Thank you. Also, I'd like to thank all the mentors. Mrs. Uche, you are amazing. Thank you for always coming and always looking beautiful. You're always setting the standard, like, okay, this is it, both intellectually, physically, like, you're just amazing. Thank you so much, Ma. Thank you, Mr. Ayokunle. Thank you for coming. Thank you for taking this mentorship personal and for coming and giving us 110% every Friday. And to Mr. Folarin in absentia, we also want to thank him so much. Right from the first quarter, he has been here and he has always been coming. Thank you so much. And I also noticed that Regina was here Motunrayo was also here. Thank you
Yes.
so much for coming. Thank you for staying. I would like to say a big thank you to the mentees. Thank you for always doing your reports, sending in your questions. And I believe that these 9 weeks have been very impactful. Next week is going to be the closing ceremony. We have someone coming in from JIIPCC. He's an executive director of that particular company, and they are permanent observers with WIPO. And we'll also be having a son coming to talk to us. And the mentors will be telling us how to actually get the big IP jobs. Alukanaye is an amazing firm. So I'm sure they'll tell us tips, tell the mentees tips that just in case you are thinking that you want to come here, these are the things we look out for. Then those who have started their practice, like Mr. Marks, he's the founder of his practice, Mr. Folarin, they might tell us how to start an IP practice. Then someone else that's with PRS, that's like a music publishing company, she might also come to talk about how to get jobs in these big music firms and all that. So please let us be here next week Friday as we have our closing ceremony. I'm so grateful to everybody that has made this a success. Have an amazing weekend.
And you too. Thank you so much.
Thank you.
Bye.
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 Bye, Mama.
Thank you, Ma.